Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
What is the matter about?
This is the appeal against the order of the Honorable Single Justice.
Yes.
So there is a delay.
No, that's all right. What is the substance of the appeal? What is the matter about? Merits?
This petitioner was appointed as a temporary employee.
Petitioner was?
Appointed as a temporary employee.
Yes.
For 3 months, and after that, it was extended, and it is gone about more than 5 years.
Where is the judgment?
It's 26 years.
Nothing. Nothing in your appeal.
Your Lordship,
You're completely prohibited by Uma Devi. Forget anything else. You're completely prohibited by Uma Devi. Temporary post not done through advertisement. There's no right of regularization. Uma Devi is a complete answer, though there's no reference to Uma Devi over here.
Your Lordship, in the state of Meghalaya, there was some scheme also has subsequently come up.
Whatever, the judgment is perfectly in order. We'll condone the delay, dismiss the appeal. No merit in the appeal.
So it's giving this some time to...
No. Waste of time. And we've made it very clear, when you come to court, you come ready for the matter. No section 5 today and another set of fees for your subsequent appeal. Nothing in the matter, nothing in the matter. Tell us your best arguable case.
So, Your Lordship, in this case, first of all, Your Lordship, when first...
Come to the judgment. Tell us which part of the judgment is wrong.
This para 9, if you come, Your Lordship.
Yes. It is settled law that no person who does not go through a regular selection procedure or is regularized their post by a competent or individual so that's the absolutely right principle.
So, Your Lordship, in this case, first of all, when these petitioners, they came before this Honorable Court, earlier litigation, Your Lordship, then it is given to consider their fair.
Consideration does not confer any right. Consideration is right to be considered. And the authority has the right to reject. It's rejected on legally tenable grounds, which has been appreciated by the single bench. Yes.
So, in the meantime, received this first litigation was pending. By this time, authority has given this petitioner to be appointed, reappointed again in a considered salary, and it was rejected. It was not accepted by the petitioners. So, subsequently, Given the so-called ruling on the basis of it, then thereafter petition was.
The only thing that you can come in is the exceptions in paragraph 53 and 54 of Uma Devi. And it's been clearly recorded, even without reference, that you don't come within any of the exceptions. Come to paragraph 9. None of the situations as set out above are present as a purely temporary officiating arrangement that has been discontinued. The marginal delay.
So, Your Lordship, in this case, that's when this petition was serving, even at that time some documents is here, even that taken as a permanent. Some
Article 14 does not apply in the negative form. That's a mistake, it's a mistake. You don't get any right because a previous mistake has been committed.
So, Your Lordship, let us have some opportunity to, because we are served for the long period, Your Lordship.
Come back tomorrow on whatever, on merits, we'll deal with the section 5 and the appeal together. Nothing. Tomorrow. Yes. Fine.
Item number 2.
Your Lordship, kindly allow this matter to come at the end of the board, Your Lordship.
Sorry?
Kindly allow this matter to come at the end of the board, Your Lordship.
End of the board.
Your Lordship.
Very good. Passed over.
Item number 2.
My Lord, they have filed an application bringing on record a birth certificate of the accused number 2, my Lord.
As per the direction of the last order, Your Lordship. So I filed the
Deal with
petition.
it.
My Lord,
an application has been filed with documents suggesting that the appellant may have been a juvenile.
But the respondent number 2, my lord.
The respondent number 2, the second respondent.
Second respondent.
May have been a juvenile at the time of the alleged commission of the offence. Full stop. The state will deal with the application and the documents relied upon by way of an affidavit to be filed within
3 weeks or 4 weeks, my lord.
within 4 working weeks, which will take us beyond the vacation. The matter will appear immediately after the vacation.
Deeply applied.
Item number 3.
Any progress?
Yes, Lordship. I filed a status report, Lordship,
Yes.
and work will be completed. The portion my petitioner is complaining about will be completed by 15th of
What about the totality of the road?
It's Lordship.
Are you satisfied with the progress, sir?
My lord, up to 32 kilometer, it is okay, my lord.
All right.
It is satisfied.
They say that up to
Satisfactory. And then
41,
31 to 41, it is not satisfactory because as per specification given to the conductor, only they are laying the stone and blacktopping they have started on 6. I have visited that area. And moreover, 9 kilometer they have given to 6 contractor, my lord.
Why is this?
Lordship, kindly
All the local.
reuse the page number 4. We have given a
Of this?
Lordship, yes.
Have you given a copy to him?
Yes.
Yes, I have got.
Lordship, here all the specific.
Page number?
This 4th page, Lordship.
You file a report in a court, High Court no less,
My apology, Lordship.
unnumbered, more often than not, they are also undated.
Column 2.
What when you refer to the 14th page? We count 1, 2, 3, 4, go to the 14th page.
I'm sorry, Lordship. Fourth page, Lordship, column 2.
Column?
Column 2, Lordship.
Column 2, yes.
This is 33 to 41, Lordship. So it has
First
been,
page is the long page.
Lordship, yes. No, Lordship. 4th page from front, Lordship.
Paging has not been done.
There are 2 pages, 1, 2, 3. Then 4th is the long page.
Then in that case, 3rd page, Lordship.
3rd page is
Column 2, Lordship.
0 to 32.
Yes, Lordship.
Time of completion, 42 months. 42 months, 42 months from when till when? So 42 months from 2020.
Yes.
Lordship, yes.
So that is about 3 years.
3.5 years.
3.5 years.
33 to 41 is 6 months.
6 months. So by 15th of December, Lordship, it will be completed.
But that person
Completed
is,
by 15th 11, this month. It's already completed, Lordship.
But why is there so many contractors for 33 to 41?
9 kilometers only.
For 9 kilometers,
Yes.
for 32 kilometers you give it to one contractor. For 9 kilometers you give it to 6 contractors.
Local
Why is
contractors.
this?
Local contractors, Lordship. Local contractors.
Maybe, but why, how do you divide it up?
Lordship, to complete the work in a fast manner, Lordship, so that it is splitted between different. Lordship, from 67 to 100, Lordship, work order is going to be given, Lordship. It is in the last page.
67 to 90 is,
Repairing work was going on, Lordship, but in view of the fact that tender has already been, Lordship, called for and lowest bidder has been selected. So
very well. 90 to 95 is 1 month.
that is repairing. That won't be required now, Lordship, because permanent work has been, Lordship, given to the person.
Where do we see that?
That in the last
What is
page,
the entire distance of the, covered by the MPT road?
133 Lordship.
133.
The last page Lordship, it will be clear, last page.
Last page.
Lordship.
Letter of acceptance.
Lordship, yes. So work has been also, this lowest bidder has been,
Just a second.
Lordship will recall that 66 crores were Lordship approved.
So 67 to 100.
Lordship, yes.
And what about 100 to 133?
That is in, Lordship, it is in good
That,
condition.
that road is completed, my lord. It is in very good condition.
That work is complete.
Yes, from Tura to Garobada. Garobada to Tura, my lord. That road is,
Karabada to Tura is complete.
yes, that is in good condition. Always it is good condition. Only this plain well area is worse condition, my lord. Because VIP is not running that road. That is the reason. My lord, this 40,
Anyway,
30,
there's been sufficient progress and we can do only
yes, my lord,
so much and no more.
yes. No,
But
it's
there is sufficient justification,
yes, my lord.
because if you see, there are two successive stretches
Yes.
which have been awarded to 5 and 6 respectively.
Yes,
And all of them have been done in 2022 after the prodding of the court, so as to expedite the matters.
That's it.
So that's a justifiable explanation.
Only by here prayer, my lord, of 32 to 41, my lord, what they are doing now, it will not last even 1 month also, my lord. Before, while the case is pending, 2 times they are prepared. Within 1 month it has gone. Again they are given to the local contractor. That also 9 kilometer 6.
32 to 41.
Lordship, yes.
Do
State
you have the
correspondent
contracts
to-
here?
Lordship.
What is the extent of the work? What is the work that you have awarded, 32 to 41?
Lordship, on 15th of this month, it has been completed, Lordship.
That it has been completed.
Completed, Lordship.
Not yet
was a repair
completed. Only half kilometer I have seen on 6 November.
What is the nature of the work that you entrusted the contractor?
Repairing, Lordship.
Repairing.
Lordship.
What were the details? Do you have a copy of the contract?
I don't have it right now,
Just try and see what is the nature of the work entrusted.
Lordship.
Their specification,
The
there is no-
specification is there, Lordship. That long page, Lordship, is there in details.
Where?
The long page, Lordship.
Tell us, show us from where?
as per they are not doing, my lord.
Detailed specifications are given.
From 7 to 12.
Lordship, yes.
Granular subbase with close graded material by mix in place method, construction of granular subbase by providing close spreading in uniform layers, motor grader and prepare. This is the normal road construction. There is nothing wrong in the nature of the work.
No, my lord, what specification they have given, at least they have to, contractor have to do like that only. They are not doing.
We are monitoring all the time, Lordship, and we are satisfied with the work.
No engineer I have seen, my lord. 1 week I was there, no.
Very well, we'll record your submission and whoever is the PWD roads supervisor over there, please furnish his name.
Yes.
And if within the next 3 months that road is damaged or that road gets into bad shape, then your man will have to fork out everything that he has made.
Lordship, if I may suggest, Lordship, I can take my friend, Lordship, there for spot inspection, Lordship. If he's not satisfied, Lordship,
No, we will have to accept your word over his at the moment. But then there has to be some accountability.
Lordship, yes.
In many places, we've seen roads, beautiful looking roads, but they don't last a month or 2 months.
Very true, Lordship.
That's not the,
Yes.
from the report filed by the state pertaining to the construction of the Agia Medipara Fulbari Tura bracket AMPT bracket closed road, comma, it appears that sufficient progress has been made, comma, that at least a 33 kilometer stretch has been completed and work is in full swing in the rest of the stretches. Full stop. paragraph. The petitioner, appearing in person, had complained of a 41-kilometer stretch, out of which the petitioner accepts that about 33 kilometer, that work on a stretch of 33 kilometer has been satisfactorily completed. Full stop. The petitioner, however, complains that the work on the remaining part of the 41-kilometer stretch has been awarded to 6 different contractors and, in any event, the work undertaken by the contractors is substandard. Full stop. The petitioner apprehends that within a month or so after the purported completion, the road may subside and the blacktopping may no longer be in existence. Full stop. Paragraph. Over several stretches, short stretches of the MPT road, a number of contractors have been engaged. Full stop. The state says that this has been done to expedite the work, particularly since local contractors may not have the resources to undertake work on larger stretches and complete the same within a short time. Full stop. Paragraph. As to the quality of construction in the 9-kilometer stretch of the 41 kilometer road that the petitioner complains of, the statement appended to the latest report filed see, we had told you it's undated. Reveals that the work entrusted is the usual as would be in respect of the construction or repair of any road. Full stop. The supervising engineer of PWD bracket roads overseeing the construction of such stretch is requested to ensure that the standard as required of the contractor is maintained such that there is no deterioration in the condition of the road shortly after the completion of construction. Paragraph. Indeed, the state would do well to seek a kind of warranty so that the contractors are liable to carry out repair work if a road appears damaged or gives way within a specified time after its completion, after the completion of its construction. Full stop. Paragraph. Let the matter now appear. 8 weeks hence, in the hope that substantial progress would have been made by then. Yes.
I
What are you appearing for?
For the NEC,
For the?
NEC, not National Council.
Item number 4.
Your Lordships.
Yes.
Well, this is a long saga, Your Lordships would be familiar, but at the end of the day, there are only 66 candidates who are now before Your Lordships. Well, out of these 66, 46 depend upon the correct interpretation of the requirement of age, how the age is to be calculated. 46 require Your Lordship's indulgence on that, if I can persuade Your Lordships about the appropriate orders. Well, as the rest, 20, there is an issue about allocation of marks. Of those 28, I will not press before Your Lordship because they don't have the set qualification. Therefore, there are only 12. If I can persuade Your Lordships that in those 12, there is a very clear departure from the marking as it should have been done, then I would request Your Lordships to consider remanding those 12 to the committee with fresh representations so that the committee can dispose it off in one manner or the other. Because the issue my learned friend has raised several times is an issue that we can't carry on doing this indefinitely, that there has to be a closure at some point in some stage.
What is the post?
Well, the posts are of assistant teachers in government service. Assistant teachers in government
So
service.
first let us deal with the 12, then we'll come to the other 46.
46. Well, that's, as it turns out, it seems 46 may be easier than the 12, but as Your Lordship, please.
The two things are, you've got to, personally, I'm not aware of the history of the matter, so you'll have to take me through that.
I explained that.
That's number one. Number two is that, as far as the 12 is concerned, principally, you have to make out a case of absurd marking. It's not a question of, difference of opinion. It's not a question of, the I is not being dotted or the T is not being crossed.
Yes, I
We
bow to
don't
it.
sit in judgment over that.
I bow
You
to
have to
it.
demonstrate absolute absurd marking for the court to be excited to.
Please, I'm grateful.
So that's
Because
the test that you have to.
That is clear. So I would take the 8. Very briefly, if I would explain the backdrop, because Your Lordship said that Your Lordship's not familiar entirely. Well, these are examinations of 2008 for assistant teachers. They were all over Meghalaya, they were held. There were some complaints by some candidates, some complaints by outsiders, which led to the Honorable High Court coming to a conclusion that there was a taint, there was interference with marks, interpolation of marks, public persons had made recommendations, and therefore the mark sheets had been changed and so on and so forth. This was in about 5 districts. And that matter, my lords, traveled to the High Court, from the High Court went to the Supreme Court, there was a review, etc., etc. At the end of the day, my lords, those 5 districts were given the opportunity to go in front of a high-powered committee led by the Chief Secretary to see whether their grievances could be addressed. Now, many of those grievances were addressed, many of those people succeeded. In some cases, the matter went to the extent of criminal cases being filed, and that is proceeding in the normal course. Well, as we are from 8 districts who were not part of that 5, the 5 had a CBI report. Learned Court said that the CBI was not necessary, however, there is a report, now let the high-powered committee look at this report, etc. And a similar report we made for the 8 pending districts, etc. So, my lords, the 8 pending districts are the ones that had not appeared before the Honorable Court, and therefore they came back to the Honorable Court to say, give us the same chance that's been given to those 5 districts. And therefore, in all fairness, the Honorable Court held that they may also, within a limited period that was given to them, they may proceed and get that matter also with their representations also placed before the high-powered committee. Now, the Honorable Division...
It implied that the entire selection process was stalled.
Well, at one stage it was stalled, then there were interim orders made for those who were untainted, then the entire thing was set aside.
So how many posts were there originally?
Originally, yes. Well, we are in a group of 256, and I had said last time, Alaj, that it's no longer, these 256 are not in the range of tainted candidates. Those were other candidates where there was interpolation, interference, changing of marks. These are only people who are on technical grounds who have been kept out, on technical grounds, so they're not tainted, but certainly whether they are qualified, whether they are eligible or not, your lordships will consider. But the division bench originally, when it sent five districts to the high-powered committee, had made it very clear that you can make representations. If you don't succeed and you remain tainted, then you would be permanently disqualified from a government job, and you would have to pay a fine of 50,000 and so on. So that is something that nobody can question. That was something that was said by the Honorable Division Bench, and that has remained. Now the issue really is, and my learned friend had pressed this last time, the issue is, once the Division Bench has said, we are not going to do anything, please go to the high-powered committee. If you satisfy the high-powered committee, you will remain in the job. If you don't satisfy the high-powered committee, you will be disqualified for all times to come, and you'll have to pay 50,000 as a penalty.
Initially, the 66 that you represent, or the 46 and 12 that you espouse, they succeeded.
Well, they didn't succeed because in the report.
Not at the report stage. But were the results declared before the challenge came, or the challenge came?
Well, the results were all declared.
So therefore, you had succeeded.
Quite right. So the result was questioned by some people, and some people were able to establish that there was interference and so on. As far as we are concerned, we are successful, but we have no charge of any taint, as it were. Be that as it may, but this is not a question of tainted teachers. The question is only, do they have the right age and do they have the right marks? That's all. Now, the question then arises is, has this matter once and for all settled by the Honorable Division Bench? Because we in our case, single judge had shown the indulgence to say, well, if everyone is going to the on the order of the Division Bench to the high-powered committee, we will give you time, you can also go to the high-powered committee. Now we've come back to the Honorable Single Judge to say, high-powered committee looked at 256 of us, cleared everybody, except 66. So we have a right to come back to you. The question arises from the other side is, no, you were given one last chance, and there is no further avenue before this court. And I believe that the Honorable Single Judge would have been influenced by the fact that the order originally was of the Division Bench, and if the Division Bench has said you go and you get yourself checked out, as it were, by the high-powered committee, then there is nothing more left. Our argument is the high-powered committee was not given any parameters on which they were to decide. I would assume that they were to decide as per law, as your lordships always indicates, and gives somebody a mandate that you would examine it as per law, whether it's explicitly stated or implicitly stated, but it is to be examined as per law. And I assume that the high-powered committee has taken the view that we've examined it as per law. We are before your lordships only to say that it was not done as per law, and we would have to then persuade your lordships. But when we went to the Honorable Single Judge, the Honorable Single Judge was not convinced that there could be a case really for us to reopen something that has already been put to a closure. And it's not put to a closure is what I have to persuade your lordships about. We have a chart, my lords, of the marking that has been done. I'm not expecting, and nor should I really be hoping, that this court can go into specific marks of the 12 candidates. It can't be done, it has to be done by the committee. But if in 2, 3, 4 of those, or 5, whatever, if I can show that the marking is patently unlawful or marking is patently irregular, and therefore I should have had a case to be able to explain this once more, then perhaps I will have an option to go back to the committee. My lords, if I may show the chart to your lordship, just give a copy of this chart.
So this is,
This chart that you have prepared is for the single bench.
Yeah, that's okay. What page is it?
But this was placed before the single bench.
Well, I have the record of what was placed before the Honorable Single Bench. If I may place before your lordships that. It's only the chart in this that your lordships need to look at. The numbers are the same?
Numbers will be the same, sir.
What page?
This is
What page? Well, this is the record before the...
yes, you have to give one to the other side, please.
Just give one to the other side.
Thank you. We can start seeing from the...
At page 27 of this, my lords. Your lordships have petitioner number 2. So the numbers given are as per the petitioners before the Honorable Single Judge. Your lordships will see the grand total, the cutoff is 31. The grand total that this petitioner claims is 35 or was given 35. And the allegations and observations of the committee are as follows. The 10 days certificate course undergone by the candidate as block resource person is not referred in the notification dated 24/11/2008 under the professional qualification head. Therefore, petitioner does not deserve to get 8 marks. So the petitioner had got 8 marks and thereby reached the figure of 35. Your lordships will see the justification that explanation that we have given. The petitioner has undergone 2 consecutive years of training as block resource person. Therefore, the certificate is equivalent to the BTC as the certificates are issued by DIET. Therefore, there is nothing wrong in the allotment of 8 marks. Manoj, may I, because since the single bench order, we've done some work on this. If your lordships will be kind enough to just put down below the reference page 861 in volume 2 of the writ petition.
That's not part of our exercise.
Well, Lords, I know I'm sorry that they should have had one more copy of this.
No. We are not on that. We are on the substance.
Substance.
We are on the substance.
So the substance...
The committee took relevant considerations into account and found it was not, we are not sitting in appeal over the committee's...
But your lordships can't sit in appeal on this.
It took relevant considerations into account and considered that you did not qualify. That's the end of the matter. If you say that it took absurd considerations, it would have been. It shows that resource person is not reflected in the notification. Whatever it is, it could have been an error over which we don't sit in judgment.
Well, I appreciate that, but if I may just take your lordships to the next one, which is item 19.
Yes.
Petitioner number 19. The petitioner number 19, if your lordships will see, is an interesting case. Sogo.
It is a cardinal principle, Mr. Khurshid, that your qualification will be assessed as at a particular cutoff date or as at the date of publication of the advertisement. You are qualified or not qualified with reference to that date. If you got your postgraduate certificate later or got your postgraduate degree later, you are not qualified. And that is the observation over here. Though he did not possess the graduation certificate on a date of the advertisement, yet he was given the marks for graduation. It's their judgment, absolutely correct, impeccable. Even if we were to be the appellate court, will endorse it.
I'm grateful, my lords. The only thing is, if your lordship will only consider what happened here. What happened here is they were instructed to bring their certificates to the interview. He did bring his certificate to the interview. There is no cavil on this. We accept it. Even then, the view taken by the committee is that you ought to have been qualified on that date. Please.
That you obtained the qualification subsequently and you produced the certificate at the appropriate time was not taken to be the appropriate consideration. We go by them.
Well, as the ambiguity as to when you must have the qualification is the ambiguity that I urge should have been decided.
Let us say, Mr. Khurshid, I issue an advertisement today inviting graduates for a particular post. And the selection process is held 6 months down the line. You must be a graduate to be able to apply.
I appreciate that.
So therefore, the view taken over here is a possible view, and that passes muster.
I can't argue that it's not a possible view.
That passes muster.
You also look at the next one is 39, petition number 39. The committee held that she should have been given only 2 marks for passing HSSLC in 3rd division, but she was given 3 extra marks. And the petitioner states that she is a said qualified past candidate with 2nd division in HSSLC, and the reference follows as is at page 723 at 2. So experience in teaching is what she was given the marks for, but it's been put under the wrong head. So my lords, it's in marking when there is a lot of work to be done. If the mark is deserved, but it's put in the wrong head, would that be a case where, as your lordships have said, this is not for interference, or only to the extent of saying that let them look at it afresh, in case you satisfy them, then we are fine.
No, look at your explanation, look at your justification. And on top of that, if you come to the 5th line, and on top of that, she was allotted marks by the examiners on their own wisdom, and there is no allegation of manipulation against her.
You're looking at 41, I think. You're
looking at
39.
Number 39. The extreme right column, 5th line. And on top of that, she was allotted marks by the examiners on their own wisdom, and there is no allegation of manipulation against her.
Well, that I'm afraid is not very accurate. The issue here was...
To what extent is this justiciable?
Well, it's very, very marginal.
Let's move on to your best of the 12.
Yes. All right, well,
if morning shows the day, then there is nothing.
Well, may I just leave it open? Well, if your lordship can consider just as an indulgence to let them be able to go once to say that this is the mistake that might have been made.
Mr. Khurshid, far too often, we judges show undue indulgence just because the party is before us. Whereas there are several others who are suffering, who don't have the means to even approach us.
I appreciate it. My Lord, I appreciate it. It's just a matter of teachers who've been teaching for a long time, and for them to be excluded completely. Be that as it may, my Lords, may I?
Let's move to the 46.
Come to the age bar, 46. My Lords, there are 3 or 4 things to be looked at here. If I may show to your Lordships the notification which is at page 104, the notification relating to these appointments. At page 104.
You conducted in your own way, but if you remember it right, the objection taken by the state is on the ground of res judicata or issue estoppel.
That's right.
So you demonstrate to us what was the order and how these things were left open for consideration so that you can assail it post-consideration.
Whereas, if your Lordship will then see at page 181, that's the division bench order
181 of volume 1?
of volume 1. Where did it start? Where did it start? Now his judgment begins at 111,
Yes.
and at 181, the bottom of 181,
Yes.
is that relevant portion, about the 6th to the 7th line from the bottom, where Roman 12 is mentioned. That there has been contradictions in the notification as regards the cutoff
That's
date.
13.
It's 13, I'm sorry, I didn't see that, it's 13, it's 13. That there has been
It's in
contradictions.
such fine print that it's understandable.
I think sometimes it's the angle of the light that, but I can see 13 clearly. Thank you. Well, there has been contradiction in the notification as regards the cutoff date on which the age of the candidate, because as per the notification dated 24/11/2008, it should have been first day of January of the concerned year, the year in which the advertisement is made. But as per the advertisement dated 10/12/2008, the age was to be reckoned as on first day of December 2008. That merely overage candidates have been appointed and continued even contrary to the terms of the said notification, etc., and advertisement. So, well, this is what was argued, that there is a contradiction between the date, the cutoff date for the notification and advertisement. And this matter at 183 was then responded to by the learned Advocate General.
So 181, what you show us is the submission.
That's right, Mullah, that's the submission.
And 183?
183 is the response of the learned Advocate General. The bottom paragraph there. The learned Advocate General has further submitted that the age of the candidates who had been continuously serving as school teachers for not less than 5 years, as on 24/11/2008, had been calculated as 24/11/2003, and if they were found to be within the age limit of 18 to 27 years, 32 years for SC/ST, as on 24/11/2003, they were eligible to apply as per clause 1D of the advertisement dated 10/12/2008. Thus, according to the learned Advocate General, the concerned candidates had rightly been taken as eligible. As far as my endeavor has been to find that any further application of mine on this by the honorable judges is apparent from the judgment, and I found nothing.
So there is no sequitur to this?
So no sequitur to this, so the learned Advocate General's reply seems to have been accepted. And that's what has happened subsequently when the age issue was applied to individual candidates. This is the paragraph that has ruled. And therefore, I was showing that could this have been done? Was this res judicata? If, Manoj, there are two things. One is most of us were not before the division bench. It was the other people from different districts who were before the division bench. We only came into the picture to take advantage of what they had been given, one last opportunity. So we came later to take advantage of that. So we didn't actually argue this. So if the argument is that you are stopped from arguing this because you did argue and you got a reply, you are stopped from arguing it, or you should have challenged it, and have you challenged it? We challenged this before the Honorable Single Judge. The only thing is, what are the documents that will prevail?
With respect, on the basis of your submission, you were outside, you were not in this original litigation. You wanted to take advantage of the benefit conferred by this order to a class of persons. So you are governed by the same considerations?
Well, it would be fair. It would be fair that I can't take the advantage and not be within the terms. But Lords, in order for your Lordships to arrive at the conclusion that this is res judicata, your Lordships will have to consider whether there was an examination of these two notifications.
And any opinion expressed.
And any opinion is expressed. My learned friend will certainly show any paragraph, but I haven't come across any paragraph that says this is correct, that is not correct. And therefore, I want to take your Lordships directly to the three documents that are relevant. One document, my Lords, is the notification, that is at page 104. Lordships have the notification of 24th of November 2008 at page 104.
Yes.
So there are various eligibility factors, etc., but your Lordship will come to page 108 in paragraph 28 on the cut-off date.
Yes.
If I may read the paragraph 28 to your Lordships. Interested and eligible candidates may bring their certificates and testimonials in support of their educational qualification, age, community, etc., and appear at the interview, provided that the candidates should be within the following age limits as on the 1st of January of the year in which the post was advertised. So, my Lords, it has to be 1st of January in the year in which the post is advertised. And therefore, that date would have been the 1st of January 2008, because the post was advertised in 2008. And then, if your Lordship will see, in case of candidates who have been mentioned at subparagraphs 1 and 2 of paragraph 1 of this notification, the candidate should not be less than 18 years of age and should not have crossed 27 years of age, relaxable up to 32 years in the case of SC and ST. In the case of candidates mentioned at subparagraph 3 of paragraph 1 of this notification, the candidate should have first entered service, contractual or otherwise, within the age limit mentioned at subparagraph 1 of this paragraph. So, my Lords, the cutoff date is 1st of January 2008 according to the notification. In fairness, I will read the advertisement. And the age given here is 32.
27 to?
27 relaxable to up to 32. Your Lordships had observed the other day. So the age given is 32. Then, my Lords, if your Lordships will turn to keep copies of this. The advertisement, which is at page 125.
Quoted in the judgment.
Quoted in the judgment. I'm grateful, my lords.
What is the date of this judgment?
2/11/2017, my lord.
2/11/2017. Thank you.
Yes.
Your lordships have at page 125.
And what is the date of the advertisement?
Well, as the date of the advertisement is, just give it to you in a moment. Advertisement dated 10/12/2008. 10/12/2008. So the notification is followed. It's in the year 2008.
Same year.
And therefore it will have to go to January 2008.
Yes.
However, here, my lords, if your lordship will see paragraph D.
Paragraph?
Paragraph D, 1D. Persons who possess the minimum qualification, HHSLC, PUC, prescribed for appointment as LP school teachers who have been teaching in the government LP schools for a continuous period of not less than 5 years, as on 24/11/2008, are also eligible to apply provided they entered service within the prescribed age limit of 27, 32 for SC/STs, as on 25/11/2003. So going back from 24/11, they take 25/11/2003. Whereas going back from 1st of January 2008 would have been 1st of January 2003. Well, that's the critical difference between the notification and the advertisement. That's the critical difference. Now, my lords, if I may show to your lordships the SR Rule 6. Which compilation? Well, as your lordships saw that compilation we gave just now, at page 25 in that compilation, the Marx compilation, in the same one, this SR is quoted. At page 25 it begins.
This is Government of Meghalaya Finance Revision of Rules.
Please, my lords, these, your lordship will see SR 6. Yeah, finance. Your lordship will see page 26, SR 6. Except is otherwise provided by rules governing recruitment to a particular service, a person whose age exceeds 27 years on 1st of January of the year in which the recruitment is made may not ordinarily be admitted into service of the state service without sanction of government. The ordinary limit is extended to 30 years in case of appointments to teaching posts in the college in Meghalaya, education service, appointment to teaching posts on non-technical subjects, 29 years in the case of appointment of medical graduates, and 35 years in respect of candidates in employ in aided schools for appointment to Meghalaya school service, provided they are eligible for the same otherwise and have acquired necessary experience. So, well, there are two things this SR provides, that candidates in employ of aided schools who are hoping to get into Meghalaya school service, so government schools, and are eligible, the age requirement for them will be 35 years. And at the top in the SR 6, it again mentions it has to be January of the year in which the recruitment is made.
Well, it begins with the caveat, except as otherwise provided by rules governing recruitment to a particular service. It's subject to that.
So well as there are no rules, as far as I know, there are
That
no.
notification would be deemed to be the rule for that purpose.
Well, the notification would be deemed to be for that purpose, but the notification also will say 1st of January. Notification will say 1st of January. Now the issue will be, is it 32, is it 35? Is it 32, 35? Would the notification itself reduce?
The notification clearly does not cover 1D of the advertisement.
Please, Knowledge.
Now, 1D of an advertisement is an additional benefit being conferred, that you will not be reckoned, your age will not be reckoned on 24th of November 2008, but it will be reckoned 5 years back if you were in service. So when a further benefit is being conferred, hedged with a condition, can you alter the terms of that benefit? Ordinarily, you would be ineligible. But a further benefit in addition to what you are entitled is being granted. And it's granted with a certain condition. Can you take that benefit and go back to the rules to dislodge that condition?
No, we can't do that. Clearly we can't do that.
So, ordinarily, a candidate who was more than 32, let's take the outer limit, as on 25/11/2008, as on 24/11/2008, would be ineligible. That is 1, 2, and A1, A, B, C. D makes an exception. If you've been in continuous service for a period of 5 years, then the date would be reckoned 5 years back when you entered service and not today.
We have no issue on that, policy.
Now, once they do that, once they give you that, otherwise you wouldn't have been. If D had not been there, you would have been out. D is a concession which is given. Once that concession is given, you can't twist that concession on the basis of any rule or any other.
I agree with your lordships on that. So the D is only said, because the issue of 5 years is not there. Nobody has raised the issue that you haven't worked for 5 years. The point is, are you taking the date of November for going to 5 years, or are you to take the date of January to go back to 5 years? That's the only issue. Because between November and January, I have a list here, there are many teachers, almost 35 teachers, who are covered. If it's a January date,
1, A, B, and C are governed by Rule 26 or 28 of the notification. 1D is an exception to Rule 28 by which a further benefit is being conferred. Ordinarily, in terms of Rule 28, 1D is out. But 1D is a concession that they are giving. So you can't take the concession and then go back to the parent and say that no, my age should have been reckoned.
I wouldn't argue that. No, I wouldn't argue that.
Nothing.
I'm only seeking your lordships to consider the impact. Of course, your lordships have said except as otherwise provided by rule governing recruitment, etc. So, is there a rule governing recruitment? Your lordships said the notification would be enough. But SR 6 would be overruled by a notification is the question that I ask myself. SR 6 clearly allows up to the age of 35. Whereas the advertisement allows
1D is an exception to SR 6. In terms of SR 6, 1D should not have been there. 1D is in addition to SR 6.
May I read that again, my lords?
Yes.
1D. Persons who possess the minimum qualification prescribed for appointment as LP school teacher who has been teaching in the government LP schools for a continuous period of not less than 5 years, as on 24/11, are also eligible to apply provided they entered service within the period and age. So, there are two parts of this. Those who've been teaching for 5 years, that's not an issue. There is no additional thing that I'm getting. The only point is, are they to take the date of 24th of November or are they to take the date of 1st of January?
No.
The notification gives the date of 1st of January. The SR6 gives the date of 1st of January. Everywhere they've taken the date of 1st of January, they've suddenly introduced 24th of November. Would that, in all fairness, my lords, to somebody who is applying, will that, in all fairness, not deprive that person of a legitimate expectation that all these are done on the 1st of January, and if it's 1st of January, then I'm clear, but if it's later than 1st of January, then I'm not clear. Well, that is...
First and foremost, I don't think the principle of legitimate expectation, as we know, would apply over here. Secondly, this is a clear conferment of an additional benefit. If D had not been there in 1, your class of persons could not have come and said that take us in. D is an exception, D is a concession given, which is a matter of policy in consideration of your having served for a period of 5 years. We will take you in as long as at the time of joining you met the age qualification. So that's an additional concession that they've given. This has nothing to do with SR5 or 28 of the notification. Because in terms of either, this class is excluded. An excluded class has been included.
Well, I need to answer your lordship's question. Well, it's, if D was not there, in the advertisement, it isn't that I would be excluded. It wouldn't that I would be excluded, because the eligibility, what I require to be able to apply, those eligibilities apply to me. They do. Well, it's, D simply says that there's an alternative. You can even come under D as an alternative. But if you come under D as an alternative, then we've put this down as a date.
Question, Mr. Khurshid. You're a 35-year-old at the time that advertisement is published. You have much higher qualifications than the advertisement requires. Are you eligible to apply?
Well, if your lordship will see, assuming that I have the qualifications or higher qualifications, your lordships have said, I have those qualifications or higher qualifications, but I have to see what what is the cutoff date. The cutoff date,
we've given you a simple question. You're a 35-year-old as at the date of the advertisement. D holds, D, 1D. You fulfill all other qualifications.
Please, my lords.
Are you entitled to apply?
Because I'm not entitled to apply. If the age is 32, then I'm not allowed.
Exactly.
I'm not.
So, D carves out an exception. D says that your age as of the date of the advertisement or on 1st of January 2008 is irrelevant. They take you back beyond 1st of January 2008. They take you back to a date anterior to 5 years before the advertisement.
That's right. They take me back five years, etc.
So they give you not 32 years, in effect they have given you 37 years. Having given you 37, you can't say I need 37 and 9 months or 11 months.
Well, I see your lordship's point, but that in fact is taking a notional advantage that I seem to be getting. Well, may I put it differently? May I put it like this? The advertisement says you must have the following qualifications. The advertisement says with these following qualifications, you must be 32 years old, because that comes from the 5 years that they gave to 27. You must be 32 years old, or you must be 35 years old. The issue is only on the day, Manoj, if I don't succeed on 35, then I'm really arguing a mere theory if I don't succeed on 35. The issue is whatever the cutoff date, whatever the age is, because the correct age is 32 or 35, is that to count from the 1st of January or is it to count from 24th of November? Now, across the board, they have used 1st of January as the cutoff, including in the notification. Well, as if your lordships go back to the notification for a moment.
Now, Mr. Khurshid, instead of going back to 5 years over here, 1D may also have been 3 years.
It could have been 3 years.
It's a decision, it's a policy decision.
It's a policy decision.
With which we can't interfere.
Could have been 3 years.
It could have been 1 year, it could have been 2 years, it could have been 3 years. What if it had been 3 years? 5 years continuous teaching with 3 years. Would your argument hold water? If it does not in respect of 5 also.
Well, if it was 3 years, they had a choice. That would be an additional eligibility that you should have been teaching for 3 years. You should have been
No, not for 3 years. That if you were teaching for 3 years, then for a continuous period of 5 years, then you'll get a 3-year additional age limit. In effect, what has this done? This has said that if you've been teaching continuously for a period of 5 years, then you would get a 5-year. You could be teaching for 10 years, but your age would be reckoned as on a cut-off date which they've indicated. And if you are within, say, the age is 18 to 27 or 18 to 32, if you have joined at age 18 on November 25, 2003, then you would be eligible anyway.
That's right.
You would be eligible anyway.
That's
You're not taking advantage of that. But what they've done is they've stipulated a particular cut-off date by giving you a 5-year benefit. Once they have done that, they've moved away from SR6. SR6 permits, because the opening line says subject to that, it permits. So they've made an exception of SR6 and given you a 5-year benefit. Similarly, they've made an exception of the notification that they are governed by and given you an extension of an additional 5 years age limit. Once you've done that, you can't add to that by any.
Well, I deeply appreciate that. Maybe I have not been able to put this across. Well, as 5 years advantage, 5 years requirement is neither here nor there as far as I'm concerned, because that's not been an issue. Have you done 5 years? Have you not done 5 years? Etc. is not an issue. The issue is which day do you count it from? 1st of January or 24th of November? If it's counted from 24th of November, I may not be included.
Yes.
I may not be included. If it's counted from 1st of January, I may be included.
Yes.
So, well, that's essentially, that is what I am to argue. Then again, Manoj, this is about people who are 35 years old, but there was also an argument for people 40 years. Well, it's the issue, I may just leave it, I think maybe it doesn't help me too much, but the issue is is there a distinction drawn between government-aided schools and government schools? Is there a distinction to be drawn that in government-aided schools, you can apply till the age of 40, in government schools, you can only apply to the age of 32, and if you have 32, then you cannot, if you cross 32, then you cannot go any forward.
There are two answers to that. One is that your SR6 says the caveat, the notification is there, the notification indicates the bandwidth, so to say, of age. Then your advertisement comes. Your advertisement 1A, B and C are in consonance with 28 of the notification.
That's right.
1D is an additional benefit. You are not covered by 1D. 1A, B and C is the same answer. I don't think there's anything else to it.
I'm grateful that your lordships at least allow me to attempt to persuade your lordships on this.
Thank you.
I'm deeply obliged for that.
The respondents have not been called upon. Paragraph. Two primary issues have been raised by the appellants in assailing an order dated,
Order dated.
impugned order,
17/8/2020.
17th August 2020.
August 17, 2022, by which the a writ petition filed by the 66 appellants was dismissed. Full stop. Of the 66 appellants, it is the case of 46 appellants that they have been unfairly discriminated on the ground of age. Full stop. A further case has been made out in respect of 12 other appellants to the effect that they were unfairly marked by the high-powered committee while reconsidering the original assessment made. Full stop. As far as the remaining appellants are concerned, no special case has been made out in their favor. Full stop. In a sense, the dismissal of the appeal qua the balance 8 original writ petitioners has been accepted. Paragraph. As to the, please take your seat, Mr. Please. As to the erroneous marking of the 12 candidates, the appellants rely on the records before the single bench full stop. A chart has been prepared where the individual grievances of the 12 candidates have been indicated. Full stop. Paragraph. At the outset, it may do well to appreciate the principle before embarking on the assessment on such aspect. Full stop. A court is not an expert to assess the level of, to assess the competence of participants at a public examination for a particular appointment. Full stop. The court is excited to look into any erroneous marking if it plainly appears to be absurd in the sense that no reasonable person in the position of the person assessing the paper would have assessed it in the manner it has been. Full stop. It is a high test that a person questioning the assessment has to pass before the court requires a reassessment to be made. Full stop. A mere mistake or the failure to dot a few I's or cross a few T's would not prompt the court to require the assessment to be gone into afresh. Full stop. Paragraph. In all fairness, it must be submitted, it must be recorded that the cases of the first 3 on the list of the 12 were pursued. Full stop. As regards original writ petitioner number 2, the High Court committee which re-examined the marks allotted indicated that the candidate does not deserve to get 8 additional marks because of the quality of the certificate course undertaken by such candidate and a notification of November 24, 2008. Full stop. To justify that the candidate was entitled to the 8 additional marks originally allotted, it is suggested that the candidate had undergone 2 consecutive years of training as a block resource person and was, as such, entitled to a certificate equivalent to BTC, full stop. These are matters which are not justiciable, full stop. As long as it is evident that the authority tasked with the duty had applied its mind to it and had taken relevant considerations into account, the court in exercise of its authority under Article 226 of the Constitution will not act as an appellate forum. Full stop. In respect of the original writ petition paragraph, original writ petitioner number 19, the High Court committee observed that such candidate did not possess a graduation certificate as at the date of the advertisement, though at the time of presentation of papers post the selection process, a graduation certificate was produced, full stop. Ordinarily, the principle is that the qualifications which are required are to have been in place as at the date of the issue of the advertisement, and the subsequent acquisition of the qualification would not make the candidate eligible to apply. Full stop. In any event, the test required of the court in such a scenario is to see whether one of several possible views has been taken by the relevant authority, full stop. In the present case, it is apparent that the only possible view has been taken by the High Court committee, full stop. As far as the paragraph, original writ petition number 39 is concerned, the High Court committee observed that she should have been given only 2 marks for passing HSSLC in 3rd division, but had been unfairly given an additional mark in the original assessment. Full stop. The argument put forth on behalf of the candidate is that after improvement, she scored 2nd division and therefore she may have been entitled to the additional mark allotted. Full stop. More importantly, this is what the candidate suggested, open quote, ... On top of that, she was allotted marks by the examiners on their own wisdom, and there is no allegation of manipulation against her. Full stop. Close quote. At this stage, it may require a bit of history to be recounted. Full stop. The matter pertains to a selection process for the post of assistant teachers in government aided or government schools.
Government schools.
In government schools in the state, full stop. Upon a challenge to the selection process, comma, the matter culminated in the selection processes undertaken at several of the centers being annulled in the sense that the successful candidates were required to be reassessed by a high-powered committee. Full stop. It is the case of the appellants herein that though these appellants did not belong to the centers which were tainted, comma, so to say, comma, since the candidates at the other centers had been given an opportunity for their marks to be reassessed, comma, the appellants also sought and obtained a similar order, pursuant to which the appellants' cases, appellants as apostrophe cases, were also re-examined by the high-powered committee. Full stop. Paragraph. In the light of the hopeless cases of the original writ petitioner numbers 219 and 39, comma, the similar specious reasons for seeking a reassessment of the remaining 9 of the 12 candidates in such category has not been pursued. Full stop. Paragraph. At any rate, comma, the grounds put forth in the relevant chart relied upon by the appellants in respect of such 9 other candidates are no better than the grounds already noticed in respect of the 3 others specifically referred to here and above. Paragraph. The discussion now moves to the 46 other candidates who complain that they have been discriminated against on the ground of age, despite the consideration in such regard being flawed if the subsidiary rules and the relevant rule pertaining to the notification were to be taken into account. Full stop. Paragraph. For such purpose, comma, SR 6 notified in the state in 2014 has been in 1984 has been relied upon, set out SR 6 from page 26 of the compilation. Paragraph. The appellants also rely on the notification that preceded the advertisement in respect of the recruitment process, full stop. Such notification of November 24, 2008 provided as follows in clause 28 thereof pertaining to the eligible, pertaining to the age of the candidates. colon, set out 28 from page 108 of volume 1. Full stop. The advertisement was issued on December 10, 2008. Clause 1 of the advertisement, published in pursuance of the notification of November 24, 2008, specified the eligibility and educational qualifications. Full stop. The relevant clause is set out. Set out clause 1 from page 125 of volume 1. Full stop. It is evident, on a plain reading of the aforesaid clause, that the normal rule as to age qualification would apply in respect of those governed by clauses subclauses A, B and C of the educational qualifications. In other words, those covered by subclauses A, B and C of clause 1 of the advertisement would be governed by the age requirement as indicated in clause 28 of the notification of November 24, 2008. Full stop. There is no doubt that clause 28 of the notification would be governed by SR 6, subject, however, to the caveat at the beginning of SR 6. Full stop. Paragraph. As per the advertisement of December 10, 2008, an additional benefit was conferred to a class of persons who possess the qualification of being in 5 years continuous service in teaching in government LP schools, provided that as on November 25, 2003, which is 5 years prior to the cut-off date indicated, they possessed the ordinary age qualification. Full stop. For clarity, the ordinary age qualification would be 18 to 27 years, relaxable to the higher limit of 32 in respect of scheduled caste and scheduled tribe candidates. Paragraph. Since the consideration here pertains to the upper age limit, it is such aspect which may be looked into. Full stop. Clause 1D of the advertisement permitted candidates who were in 5 years continuous service in government LP schools to
to apply for the post provided they had not crossed the age limit of 32, the maximum possible, within bracket, the maximum possible, as on November 25, 2003. Full stop. Clause 1D was an exception to Clause 28 of the notification of November 24, 2008. And Clause 1D would also pass muster in terms of SR6, since such rule gives authority to additional or other specifications being stipulated as to age, as long as it was not in derogation of the substance of Clause 8 of SR6. Full stop. Paragraph. By no stretch of imagination, may Clause 1D of the relevant advertisement be seen to be in derogation of SR6. Full stop. If the age limit of an eligible candidate had been abridged to below what was provided in SR6, that would have been an aberration. Full stop. When the age limit had been extended by way of Clause 1D as in an additional, as in a concession granted in respect of a class of candidates who were already in service, neither SR6 nor Clause 28 of the notification of November 24, 2008 would come to the aid of the candidates who were overaged as on November 25, 2003 for them to be considered for the appointment. Full stop. Paragraph. In simple terms, when a class of persons is conferred a benefit which it would not have otherwise been entitled to, and the benefit is hedged with certain conditions, it is the entirety that has to be accepted or not at all. The benefit cannot be divorced from the conditions attached thereto. Full stop. Paragraph. By the judgment and order impugned, the single bench found no merit in the case of the 66 petitioners before it. Full stop. As indicated above, the case of 8 of the original petitioners has not been espoused in this appeal. Full stop. In respect of 12 candidates, the contention was that they had been marked erroneously. Full stop. Such aspect of the matter has been dealt with here and above. Full stop. In respect of the balance 46 candidates, the contention that by virtue of SR6 or Clause 28 of the notification of November 24, 2008, the date of reckoning should have been January 1, 2003 instead of November 25, 2003 does not hold any water. Full stop. Paragraph. There is no merit in the appeal and the same is hereby dismissed. there will, however, be no order as to cause. In the appeal, specify the appeal number.
Malaj, I'm grateful for your Lordship's patient hearing. May I seek your Lordship's indulgence in one matter? Malaj, would your Lordships consider, this has been a complicated case, there is no taint involved, as I've argued repeatedly. Malaj, at least the embargo on them and indeed the fine or penalty placed on them, could your Lordships consider waiving that?
Wrong person.
Malaj, it's...
Wrong person.
It was obviously done keeping in mind that there were serious questions of integrity involved.
Same thing. You put your head on the chopping block.
It was my duty to ask your Lordships.
Thank you.
Show some compassion.
Thank you.
I'm deeply obliged, Malaj. I'm deeply obliged.
Item number 5.
Yes, sir.
But I have to justify quantification. Before that, I make a few submissions. But the coming project was awarded for a total sum of rupees 234 crores. Out of
What did it entail? Construction of what? A dam?
well,
Bridge?
it's a dam cum power project, ideal project. It has mainly two parts. One is the steel liner with steel ferrules. It's long pipeline which ultimately goes to the turbine to supply water to make the turbine rotate. The other part is erection of gates. Now, at that time, when this contract was awarded, the grade of steel specified was not manufactured regularly in India. So, in the contract itself, a total quantity of steel worth 75 crores was to be imported from either Europe or US. And the
Steel imported from US.
it's not US, Europe.
US does not manufacture any steel.
I'm sorry.
It only uses the poor countries to manufacture the steel because it's a polluting industry.
Yes, I'm sorry,
Yes.
It's the European countries which mainly supply this grade of steel. And the hydraulic hoist, that was worth 12 crores. So out of the total contract of 234 crores, this 87 crores worth of foreign import of steel and hoist component was part of the contract, part of the tender, and it was approved. Now, this contract was awarded in 2005, January 2005. The total period for this contract was 51 months. It was to end in 2009, April. So it's a large quantity of steel, as per the approved drawings, up to that 2009 date, was imported. But since another very huge quantity was not imported because of design and drawings were not finalized and approved, So that quantity was imported after the completion of the contract period. Now, my lord, what happened, my lord? During this large period, my lord, the contract actually, my lord, ultimately completed in 2017. So it's a period of almost 12 years, my lord.
What was the original date of completion?
The original date of completion was April 2009. My lord, in this very large period of 12 years, when the import was to take in phased manner in about 4 years, 51 months means 4 years, 3 months, the prices, my lord, internationally as well as in domestic market, went up. One is the market price, that went up. But one thing, my lord, I must have marked that during this period,
The dollar rose, will be fair.
we have lost.
Provided there is any currency fluctuation clause.
My lord, I am coming to that. Then, my lord, once this happened, my lord, and the contractor was required to import a large quantity of specific grade of steel after the contract period. And both these two factors, my lord, one is the price in the market, international market, going up, as well as the dollar and euro also going up. This was a double
Jeopardy.
hammered jeopardy on the contractor. So the contractor made
Sir, we are not asking you for justification.
Well, I know.
Justification there is. He has blamed the employer for the delay.
Well, the employer,
So employer suffers, but just because there is delay does not entail that there must be damage. So quantification of damage is necessary. We are on quantification.
my lord, I get what is falling from my lord. My lord, what the appellant has.
The moment we ask you on quantification and you go on to cause, that arouses the suspicion that there is nothing on quantification. That's why you're emphasizing on cause.
No, I'm just giving this background only to show subsequently what I want to show to my lords. My lord, the appellant here has only given the chart.
C13.
My lord, the chart at 410A. My lord, can you have this chart, my lord?
Yes. What is the document called? C something?
My lord, C13. My lord.
C13. Yes.
So, in the form of C13, my lord, the appellant has only placed these 2 pages before my lords. One is, both are in a way calculation charts. But this C13 contained various other documents, which is, I have, my lord, placed on record by this small compilation.
Where is that?
It is filed, my lord. So, one by one, I'll show as to
Exhibit number 13.
13, my lord.
So it had 12 pages.
It has 12 pages. So, they have only filed 2 pages. These 12 pages, my lord, are the dollar and euro rate on the date of the contract, and then, my lord, the dollar and euro rates which were prevalent on the date of.
Very good. Now, shows the award and shows that he has applied his mind to that. The award is part of the compilation.
Award is not part of this compilation. My lord, the award, my lord, they are filed with the appeal, my lord. My lord, the appeal paper book may kindly be taken up. My lord.
Yes. Where do we find the award?
My lord, the appeal, my lord, page 134 is
134.
Where does the award begin?
No. Page 94 is the quantification.
No. Where does the award begin?
The award begins on page. Award begins, my lord, at page 65.
We have some wrong papers. We don't have 65.
My lord, page 65, the award starts.
Actually, in our case,
My lord,
65.
65, my lord, of the paper book, of the appeal paper book.
So it's an award dated 23rd April 2017. Yes, the relevant part is at 94.
94. My lord, page 92, my lord,
92, yes.
92, 5.33, my lord.
Yes.
As discussed above, Exhibit C13 Collie has stated the loss incurred due to foreign exchange variation while procuring imported steel liner plates, giving the statement regarding phase-wise procurement of steel plates liner by the claimant with respect to PSC issued by the respondent and also while procuring hydraulic cylinder from abroad. The respondent, as noticed above, has not challenged the same at all. The claimant, however, by amendment, has reduced its claim from 9 crore to 8 crore towards principal amount. But this was because two of the invoices were later on found to be within the period of contract. Those two invoices were by amendment application was deleted from the chart and the rest were kept. Now, my lord, I show from these documents how this chart, my lord, is substantiated. Now, my lord,
You read 534.
534. The respondent claims, in view of clause 74 of condition of contract, which provides for price adjustment variation, the claimant is not entitled to anything as against claim number 2.
All right, now stop here for a moment.
Well, now, Lord,
Now,
how
come
this
to your chart.
chart.
Where do we find the rates in your chart?
Well, the chart, the first chart was filed with the Annexure 13 was amended. Well, that amended chart is at page 93 of this small compile. Page 93, my lord.
Yes.
Now, my lord, first is the rates.
Rate.
Rate, my lord. Well, the serial number 1. Now, the dollar rate, my lord.
No, forget dollar rate.
My lord.
First is rate of the thing. In 1040, come to column 6. Rate per meter in dollars.
My lord.
So, column
6, my lord.
column 6, yes. So it's 1040.
My lord.
This is of the previous acquisition.
My lord, this is, no, my lord, these are after the contract, my lord.
Now, what does the contract say about the rate?
But contract doesn't say anything about rate.
Show us where this steel is to be acquired from abroad. Show us that.
But that record is not here, my lord. The contract document is not filed.
You are trying to climb a mountain that is absolutely impossible. There is nothing which is indicated by the arbitrator.
My lord.
You are trying to say that everything was there for him to accept.
My lord.
But it is apparent that the arbitrator did not apply his mind. If he applied his mind, he would first have said, this is the rate they are entitled to in terms of the rate.
despite their objection under clause 74 that rate appreciation they are not entitled. So first the arbitrator had to apply his mind. What was the rate at the time of the contract? What was the rate at the time of its acquisition? Whether there is any change, if there is any change, whether they are entitled to the enhanced price. Dollar appreciation goes subsequent.
Well, it is not the rate appreciation that is claimed under claim number 2. It is the dollar or foreign currency appreciation that is claimed, only that is claimed, not the rate appreciation. The admitted cases, rate appreciation is covered under the escalation clause in the contract. Not the dollar.
Page 93, sir.
93.
This is the arbitrators, this is the award, this is not nothing else.
No.
Page 93, clause 74, this is their submission. Clause 74 deals with price adjustment, price variation, which applies if there is variation of price of the material, except for those materials supplied by the corporation, as well as if there is increase or decrease in the local currency cost of labor and in high-speed diesel. The said clause does not apply when the contractor suffers loss due to foreign exchange variation.
Yes. So the price variation is the market price variation of steel in the foreign market.
So where does the arbitrator apply his mind that in obtaining the subsequent quantity, the price of the material did not change, and what he is awarding is only on account of currency fluctuation? Where is that? There is no such finding.
The said clause does not apply when the contractor suffers loss due to foreign exchange variation. It is not the case of the claimant that the cost of material in terms of USD or Euro has increased. The case of the claimant, as discussed above, is that though the cost of material remains the same, the variation of foreign exchange rate in INR versus vis-a-vis USD and Euro, for which it has suffered losses, as the procurement
Very good,
of material.
very good. Now show us what is the rate. Show us what is the rate. Where? How did the arbitrator apply his mind? What is the rate? You've given a rate in the chart.
Rate of I have given the rate of Euro and
Forget Euro. Let us come to the quantity. The material. You've given a material rate. Yes. Where do we find these rates which appear at page 93, column 6?
These rates are
1040, 1250, 1230, 1200.
I am just showing that.
Yes.
This is at page 134 of this compilation.
134 of the same compilation.
Same compilation. I would find that 1040.
This is invoice.
Invoice,
We are not concerned with invoice. We want the contract price.
The contract price,
What was stipulated in the contract between the parties? This is invoice with the third party.
as per in the contract, there is no specific rate for steel or imported item. It is the contractor who has to quote the quantity and the price.
Show us that.
That is
Shows the relevant clause which governs the contract.
That contract has to be placed on record. That is a part of the arbitral record before the lower court that is there.
The arbitrator does not notice that.
Yes, it was before.
In paragraph 5.34, that is not indicated.
The rate in the contract was not in a matter of dispute, my lord. Rate in the contract was for the quantity.
Do you have the contract? Do you have
the contract is not here, my lord. The contract then has to be filed with my lord.
Try. We can attempt. We are not happy.
My lord, I
8 crore is being awarded on the basis of 16 lines against a public company. No.
My lord,
even getting your contract may not help you. Easier way would be to accept it, go back for quantification. We'll set aside, we'll only leave one issue open, which is quantification. If you're right, you'll get the same answer. In a 50-page award, 60-page award, The key part is how much? 8.5 crore has been awarded on the basis of 16 lines without any explanation.
Well, may I make an attempt, my lord? Well, my lord, the contract was not part of the arbitral record also.
Contract was not part of arbitral record. So how did the arbitrator assume?
Well, because in contract there is no rate for imported steel. Contract specifies a particular 16,000 metric tons, my lord. That 16,000 metric tons was to be imported, my lord, for 75 crores, which is 46,000 rupee per metric ton. At the time of import, this went up to 59,000 per metric ton. So there is no rate in.
So where is that? That has to be indicated. Exactly what you said. If that had been there in the award, we wouldn't have. We only look for a little bit. Because over here in arbitration awards, our hands are our role is very limited.
I appreciate, it is this,
but if that is not there, when a quantification is made, if that is not there.
Here, my lord, I have to satisfy the concerns of my lord. My lord, that's the part, my lord. So, my lord, I file that part.
When will you come with the contract? Even if you come tomorrow, we are happy tomorrow.
My lord, tomorrow the papers are not available. My lord, I'll give me 1 week. I'll file it. 2 weeks, my lord, 2 weeks.
The respondent seeks a further 2 weeks to file additional papers, full stop. Leave is given to file additional documents, subject to the caveat that such documents ought to have been a part of the records in course of the arbitral reference. Full stop. It will be open to the appellant to object to any document included, any documents ought to be relied upon by the respondent if such document did not form part of the records before the arbitrator. Paragraph, this is the matter a week after the vacation.
Lord, may I make a submission, my lord?
Sorry?
May I make a submission, my lord?
Yes.
The submission is, but the arbitration proceedings, my lord, what happens in arbitration proceedings, it's not a very streamlined proceedings. The arbitrator many times, my lord, asks for bringing the documents and show to him. And it is, my lord, it happens, my lord, in many arbitration that goes like that. And they may not be placed on record.
We have another way. We can call for the records from the arbitrator himself.
Lordship, records are with
Records are with the court.
Judge, commercial court.
Commercial court.
The records are lying with the commercial.
Lying with the commercial courts.
We will look at only such records which form part of that and not beyond it.
Well, that's what the submission I was making.
No, sir, we are not entitled to do anything beyond. Anything beyond means that the arbitrator did not have an opportunity to apply his mind to that. And what the arbitrator did not have an opportunity to apply his mind over, you cannot bring it in justification of the award.
Well, I fully appreciate.
It's a very simple principle.
Fully appreciate.
That's why we are saying, go back now, you will finish it in a hurry and come back.
Then, let us remit back to the arbitrator for justification.
Very well.
Lordship, only 2 points, small point, if your Lordship permits me.
What points?
Your Lordship, the delay is caused on my part. The contract provides a mechanism to deal such contingency.
From that we are satisfied that it is done. That there is enough explanation.
Right, sir.
Just to delete that. 2 issues have been raised in this appeal arising out of the rejection of a challenge under Section 34 of the Arbitration and Conciliation Act 1996 to an award dated
Dated 23/4/2017.
April 23, 2017. Paragraph. According to the appellant employer, comma, the arbitrator erroneously arrived at a finding that the delay in the completion of the work envisaged by the contract was attributable to the employer. Full stop. The more serious challenge is that once the arbitrator held that the delay was attributable to the employer, comma, the arbitrator did not embark on any exercise to assess the quantum of damages that the respondent contractor ought to have been entitled to. Full stop. According to the employer, comma, according to the appellant, comma, the arbitrator willy-nilly awarded damages as claimed in a document that was furnished and marked as Annexure C13 in course of the reference. Full stop. Paragraph. The appellant refers to paragraphs 5.33 and 5.34 of the award to suggest that there is no application of mind to the matters in issue and not even a subjective satisfaction that the contractor was entitled to the quantum claimed. Full stop. Paragraph. It is necessary to see the relevant paragraphs in the award where an attempt at quantification appears to have been undertaken, colon, set out paragraphs 5.33 and 5.34. Paragraph. It is elementary that in a claim for damages, comma, it is the factum which has first to be established before the quantum is ascertained. The first part of the assessment, comma, therefore, is the grounds for the claim and the justifiability thereof. Full stop. In the present case, the primary ground for seeking damages was the delay on the part of the employer in providing drawings and designs that resulted in the contractor failing to obtain the material within reasonable time. Full stop. There is no doubt that the arbitrator went into the aspect of delay in great detail and rendered a view that the delay as claimed by the contractor was solely attributable to the employer, full stop. What follows from such conclusion is that if the contractor had suffered any loss or damage on account of the delay, which was solely attributable to the employer, the employer would have to make good such loss by way of damages. Full stop. However, it had first to be ascertained whether any actual loss was suffered. Full stop. It is quite possible, as in contracts of high sea sale or the fluctuating prices of food grains or precious metals, that delay does not result in loss. Full stop. The fact that there was delay on the part of the contractor had to be seen in the context of the prejudice suffered by either party as a result of such delay and the quantum of damages assessed thereupon. Full stop. Paragraph. Though the respondent submits that the principal part of the claim was on account of the falling rupee against the dollar and the euro, US dollar and the euro, there does not appear to be appropriate application of mind in such regard by the arbitrator. Full stop. The respondent submits that certain grades of steel which were not available in the country at the time that the contract was entered into had to be procured by the contractor from international markets. Full stop. The contractor submits that because of the delay in obtaining drawings and designs and the consequent assessment of the quantum of such grades of steel to be procured, the appreciating euro vis-a-vis the rupee,
dollar,
resulted in the contractor having to pay much more to acquire the quantity of the material that was, more or less, indicated in the contract. Full stop. Indeed, the respondent relies on the rates of the currencies indicated in its documents appended to C13 and submits that the 2 pages from C13 that has been relied upon by the appellant indicate the rates of the material acquired from foreign sellers, but the other pages which formed a part of C13 indicated the currency fluctuation and the basis of the claim. Full stop. A copy of the entirety of C13 has been furnished on behalf of the respondent. Full stop. It is evident that certain quantities of goods acquired and the rates paid therefore are indicated in the initial pages, and several of the documents are certificates obtained from the Reserve Bank or appropriate or other sources as to the currency fluctuation. Full stop. However, paragraph, however, what was submitted by way of a claim, whether in an abridged or in a chart form insert annexure C13, had to be assessed by the arbitrator by referring to the clauses of the contract, if relevant, as to escalation or currency fluctuation, and arriving at the quantum due to the contractor on account of the delay on the part of the employer and the resultant fall in the value of the rupee qua the relevant foreign currency. Full stop. This exercise is singularly lacking in paragraph 5.34 of the award, which can be said to be the only basis for awarding damages in excess of rupees 8.34 crore. 8.74 crore. Paragraph. Section 31 of the Act of 1996 requires an award to be reasoned. Full stop. Whenever a finding is rendered, reasons must accompany the same to indicate the journey undertaken by the adjudicator from the facts to the conclusion in the backdrop of the law that is applicable. Full stop. As far as the delay part is concerned, there is no infirmity in the award, as the arbitrator has discussed the matter in great detail, and there does not appear to be any infirmity which calls for judicial intervention in such regard in the limited scope available under section 34 of the Act. Full stop. Paragraph. As far as the aspect of quantification is concerned, there is no reason indicated in the only meaningful paragraph of the award that deals with the quantum of damages to be awarded to the respondent herein. Full stop. As a consequence, the award cannot be sustained. Full stop. There does not appear to have been appropriate appreciation of this part of the appellant's challenge by the court of the first instance. Full stop. Paragraph. Accordingly, the judgment and order impugned dated
5/7/2022.
July 5, 2022.
Passed in commercial court case.
Passed in
Page 97.
97.
Page 97.
passed in Commercial Arbitration number 18 of 2018 by the Commercial Court Shillong is set aside, and the award dated April
23, 2017.
April 23, 2017 is set aside by leaving the parties to work out their remedies in accordance with law.
My Lord, may I submit?
Yes.
My Lord, it was remitted to arbitrator, my Lord.
We have no authority in that regard.
My Lord, section 34(4).
That is only for
We are setting aside the award. It's for you to take steps.
My Lord,
Come to 34(4). 34(4),
my Lord,
the Supreme Court judgment is my one-page judgment from Calcutta quoted. That is the Arbitration Act.
my Lord, my Lord, I am mistaken, my Lord. Earlier, my Lord, I said, my Lord, the case may be decided on the impression that my Lord would.
We don't have any authority. Come, show us in 34.
My Lord, then, my Lord, I try to convince my Lord. Then.
No. That cannot be. After having accepted pass,
My Lord,
you take steps. We'll provide for that. It will be open for you to take steps for the reference to be made afresh to the same arbitrator. We'll provide for that.
my Lord, section 34(4) provides for that.
Let us see. 34(4). If there are no reasons, only for that purpose. That is not what we are. No. Here there has been no application of mind. That is to keep it in evidence and receive it. No.
My Lord.
No.
My Lord, may I make a submission, my Lord?
Yes.
I was greatly mistaken, my Lord. I thought my Lord would remit it back to the arbitrator.
There is no authority to remit.
My Lord, on that, my Lord, I made the submission. My Lord, I'm extremely sorry that, my Lord, I mistook and misunderstood, my Lord. And on that, my Lord, I said that, my Lord, may send it back. My Lord, may I satisfy, my Lord, because, my Lord, by filing documents, I can satisfy.
You file documents,
my Lord,
but we reserve costs assessed at 20 lakhs
my Lord.
for this exercise that you made us undergo. It's a commercial matter. You know money only. We also know money. How to hit you with money.
My Lord,
Yes.
I was greatly mistaken, my Lord.
Retain the first order, not this.
My
It
Lord.
will appear immediately after the vacation. Yes. Don't transcribe this.
My Lord, my Lord, I'm extremely sorry, my Lord. I just misunderstood, my Lord. Misunderstood, my Lord.
But you know, you should understand that in the implication of law,
I thought
there's no power to remit.
my Lord, I thought my Lord would remit back to the.
But there's no power to remit.
So,
When I mean remit, it means that you have to go for a fresh reference.
My Lord.
There's no power to remit.
my Lord, let me, my Lord, try and attempt to satisfy my Lord on this, my Lord. My Lord. I'm extremely sorry, my Lord.
Yes.
So, my Lord, I'll file the additional documents.
Yes, file it. That's what the order provides.
Grateful, my Lord.